State Bar Council Law Academy. Ladies and gentlemen, greetings to one and all present here. I'm Varsha, a student of second year LLM. Welcome to the Karnataka State Bar Council Law Academy online lecture series on Civil Procedure Code 1908. I would like to extend my humble salutations to our esteemed luminary Hon'ble Justice N.Kumar, retired Judge of High Court of Karnataka. Welcome, sir. I would also like to welcome Shri Anil Kumar JM, Chairman of Karnataka State Bar Council, Shri Gautam Chand SF, President of KSBC Law Academy, and I'm deliriously happy to welcome all the members of the Karnataka State Bar Council and trustees of KSBC Law Academy, along with guests, advocates, law students, and participants who have gathered here virtually. After the mind-boggling previous sessions, we have now arrived at the day 6 of the online lecture series on Civil Procedure Code 1908. And I'm glad that you all are extending your support and actively participating in webinar series. And we look forward for your constant cooperation throughout the webinar series. I request all the participants to post your queries or clarifications in the chat box, and it will be taken up during the question and answer session. Now, it gives me immense pleasure and exultation to welcome back our eminent speaker, Hon'ble Justice N.Kumar, who will be addressing on the topic Orders 17 and 18 of the Civil Procedure Code 1908, examination of witnesses and marking of documents in today's session. Welcome, sir, and the floor is yours.
Good evening to all of you. Now, we have seen that the plaint is drafted properly. It is filed in a civil court which has got pecuniary jurisdiction as well as territorial jurisdiction. And therefore, question of returning of the plaint does not arise. Issues are framed. The plaint discloses a cause of action. It is not barred by any law, and therefore there is no impediment for the trial to commence. Now, once the case is set down for trial, a lawyer needs to make few preparations. What are they? Now, along with the plaint and along with the written statement, all the documents on which the parties rely have already been produced. It may so happen the plaintiff may not be in possession of all the documents. Some documents may be in possession of the opposite party, that is the defendants. So before you start the evidence, you want to be sure that document which is in the possession of the defendant is relevant and material for a proper decision of the case. Therefore, how do you get it? Order 12 Rule 8 of the Civil Procedure Code provides for an easy remedy. All that you have to do is to issue a notice to produce documents from the opposite party in the prescribed form number 12 in Appendix C. All that it says is from so-and-so, addressed to so-and-so, normally defendant's advocate, and give the full description of the property which is according to you in the possession of the defendant, which you want him to produce, and serve that notice copy on the advocate of the party or any authorized representative, and file that acknowledgement into court. If the defendant produces the document, well and good. Otherwise, you will be at liberty to produce a copy of the said document, a secondary evidence. Or if you are able to show that the document is the possession of the defendant and he is not producing the document, you can request the court to draw an adverse inference. That's how a document which is not in the possession of the plaintiff, which is in the possession of the opposite party, could be summoned. Secondly, along with the plaint, you have produced documents. Earlier, the law was the suit document should be produced in original and all other documents could have been produced subsequently. Now the law is changed. You have to produce all the documents on which you rely on in one stretch along with the plaint with a list. Now the law does not insist that you should produce all the original documents. Choice is yours. You may produce, you may not produce. And if you produce certified copies, Xerox copies, that is sufficient. So if you have produced Xerox copies of the documents along with the claim, so before you commence the evidence, under Order 13, Rule 1 provides for production of original documents. In fact, the original documents are to be produced at or before the settlement of issues. Even otherwise, the parties and the pleaders shall produce on or before settlement of all issues all the documentary evidence in original where the copies thereof have been filed along with the plain or written state. So therefore, before trial, if you have not produced the original documents, at or before settlement of issues, or at least before you get into the evidence, you must produce all the original documents into court. This is about documentary evidence. Now, if you intend producing oral evidence, if you intend examining witnesses in support of your case apart from the plaintiff, the law casts an obligation on you to prepare a list of witnesses. That is, on or before such date as the court may appoint, and not later than 15 days after the date on which the issues are settled, the party shall present in court a list of witnesses whom they propose to call either to give evidence or to produce documents, and obtain summonses to such persons for their attendance in court. So witnesses are of two types. A witness who is summoned to give evidence. A witness who is summoned to produce document. Maybe you may summon a witness to produce document and give evidence. So you must be clear about why you are examining the witnesses. And you must make a list of all the witnesses and serve a copy of this. File a copy in the court and give a copy of the list of witnesses to the opposite party, so that you will know in advance who are the witnesses whom you want to examine. Earlier, when you file a witness list, normally we used to take summons to the witness to get him to the court. In 76, law was amended by introducing Order 13, Rule 1, capital A. What this provision provides is, subject to the provisions of Rule 3 of Rule 1, any party to the suit may, without applying for summons under Rule 1, bring any witness to give evidence or to produce documents. So today, if you want to examine a witness whose name is mentioned in the witness list, you need not take summons to produce that witness. You can request him. If he honors your request, if he comes to the court, that is well and good. Unfortunately, the lawyers have not seen this change in the law. Even today, in courts, you see when a witness is examined, first question is, who asked you to come to witness? Was there any summons from the court? Why have you come? What is the interest you have? To show to the court that is the interested witness whose evidence cannot be taken seriously. It is thoroughly wrong. Now the law provides for examining a witness without he being summoned through court. You have to prove your case. You are given his name. You go and request him. He is a man who wants to assist the administration of justice, who wants to speak the court, and therefore he comes, enters the witness box, takes oath, and give evidence according to him regarding the truth. So therefore, it's time that these questions, saying that why did you come, without summons you have come, you have personal interest, I don't think it takes any person to anywhere. When the law provides for it, time we should respect the law and stop putting those questions. Then, if you have summoned a person, normally a government office, where a document is lying, which they will not get it, you can take out a summons to them, produce the document. If the summons says only to produce document, that authority to whom you have taken summons, either he may come personally or he can depute some person who comes to the court, delivers to the court the original document, takes an acknowledgement and walks away. If you have summoned him only to produce documents, you have no right to cross-examine the witness. But if you have summoned a witness to produce documents and to give evidence, then after the document is produced, you have a right to cross-examine the witness. So you have to make yourself sure whether you are summoning a witness, especially an official witness, only to produce documents, only to give evidence, or to produce documents and to give evidence. So once a person is so summoned, he is duty bound to appear before the court, give evidence, withstand the test of cross-examination, and assist in the administration of justice. Therefore, before the actual trial begins, a lawyer appearing for the plaintiff who has come to court should take these precautions to see that all the documents which are not in his possession are brought to the court, and also give a list of witnesses and tell the opposite party and the court in advance who are the witnesses you want to examine. Maybe you have given a list, and if you choose not to examine, nothing can be said against you. But without mentioning the person in the list, it is not possible for you to examine that witness without the leave of the court. So these are the preparations which a lawyer has to make before he commences evidence in a court of law. Now, Order 18 is the provision which speaks about hearing of the suit and examination of witnesses. If you look into the entire scheme, this word hearing, first hearing, appears in various places. After the pleadings are complete, Order 10 speaks about the first hearing. That is only for the court to ascertain from the parties and the pleaders what the case is. Now, after the issues are framed, after all these requirements are complied with, when we have reached the stage of evidence, that is the stage which is called as hearing of the suit. And in that hearing, what we intend to do is to examine witnesses. For what purpose? Issues are framed. The burden of proving certain issues are new. If you discharge that burden and prove that case, you are entitled to that relief. So keeping that in mind, you have to examine witnesses. So therefore, Order 18, Rule 1 speaks about who has the right to begin the war. Line is drawn. Both sides are fully ready. Who has the right in law to begin? So Order 18, Rule 1 speaks about right to begin. It says the plaintiff has the right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. So therefore, generally, it is the plaintiff who has the right to begin. But if the defendant admits the plaintiff's claim and put forth a defense, then there is nothing for the plaintiff to do. Say, for example, a suit is for recovery of rent of a particular amount. The defendant does not dispute the relationship of landlord and tenant. The defendant does not dispute the rate of rent. The defendant does not dispute even the arrears of rent. He says he has paid the money. He is not liable to pay any. This claim put forth by the plaintiff is false. So once the plaintiff admits everything, and is a case of plea of discharge. So the burden of showing that he has paid the money is the defendant. Though generally, right to begin rests with the plaintiff, in view of the nature of defense taken by the defendant, where he is not disputing the claim, but he says he has discharged the claim, he has to begin. So these are all exceptional cases where the defendant would have the right to begin. Otherwise, it is the plaintiff who has come to court, who has to establish his case, on whom the burden of proof lies as the issues are framed, has to commence the evidence. Here, let me point out, in spite of a specific provision contained in the Civil Procedure Code from 1908, today in courts, neither the lawyers nor the judges are following you. So what happens in the court today? Yes, case is posted for trial. The plaintiff puts a witness in the box. Normally, the plaintiff enters the witness box. The plaintiff counsel starts the trial. What is the case about? How does the court know? What is expected at the commencement of a trial is set out in Order 18, Rule 2. If we are able to follow this, the experience of a court, experience of a trial would be wonderful. But we are doing it very mechanically. And that's why there is no charm in the trial work. If you are able to do the trial work in the way Civil Procedure Code is prescribed, it would be a pleasure. So what does Order 18, Rule 2 says? It speaks about statement and production of evidence. It says about statement and then production of evidence. What is the statement they are referring to? It says, on the day fixed for the hearing of the suit, that is the first date of hearing, earmarked for recording of evidence, or on any other day to which the hearing is adjourned. If you are not ready, take an adjournment. Get ready. The party having the right to begin shall state his case and produce his evidence in support of the issues which he is bound to prove. Therefore, it's called opening marks. It is not simply putting the witness box and start putting questions. The plaintiff counsel has to say, I am appearing for the plaintiff. This is the case of the plaintiff. In substance, in 4 sentences. This is the case of the defendant. Issues are framed. The burden of proving this fact is on me. And in support of, in discharge of that obligation. Now I am examining the plaintiff. If you want to examine any more witness, I am examining this witness for this particular purpose. It's called opening the case. See how wonderfully it will be there if such a course is adopted in the court, especially those people who are waiting in the court. They will also know what the case is. What is the case of the plaintiff, what is the defense, and what is to be proved. So they should be able to follow. And more so, the judge will be able to follow. Once the plaintiff says what his case is, yes, then the other party, the defendant, shall state his case and produce his evidence, if any, and may then address the court generally and the whole issue. So you must state the case, adduce evidence, defendant will state his case, defendant will adduce evidence, and in the end of the day, it is the defendant who should start arguing for the first time. The other party shall then state his case and produce his evidence, if any, and may then address the court generally in the whole case. Then the party beginning may then reply generally on the whole case. Absolutely, this procedure is missing in the trials. Now, for the purpose of Commercial Courts Act, this provision has been extensively amended. I do not propose to go into those questions because that is a law by itself, and I will stick to the Civil Procedure Code as applicable to the civil courts, except the commercial courts. So this is how a right to begin starts. Now, another important aspect which is to be kept in mind by the plaintiff is, if several issues are framed, it may be that all the burden of proving all the issues will not be on the plaintiff. There may be 1 or 2 issues, the burden of which is on the defendant. Now, when you are adducing evidence, the plaintiff is adducing evidence, his concern is to adduce that evidence and discharge the burden which is on him on those issues. An option is given to him to adduce evidence even in respect of those issues. The burden is on the defendant, or to wait for the defendant to adduce evidence and then evidence in reply. This is what is contained in Order 18, Rule 3. Where there are several issues, the burden of proving some of which lies on the other party. The party beginning may at his option either produce his evidence on those issues or reserve it by way of answer to the evidence produced by the other party. And in the latter case, the party beginning may produce evidence on those issues after the other party has produced all his evidence, and the other party may then reply specially on the evidence so produced by the party beginning, but the party beginning will then be entitled to reply generally on the whole case. This is the law. How do you reserve your right? The law doesn't say how to reserve it. It's a procedural law practiced in courts. Normally what is done is, if you want to reserve the right to lead evidence after knowing what the evidence of the defendant, after you have completed your evidence, the plaintiff has to file a memo. I have adduced evidence on these following issues where the burden is on me. On these issues, the burden is on the defendant. I reserve my right to adduce rebuttal evidence after knowing what is the evidence of the defendant. One memo to be filed after the plaintiff's evidence is over, before the defendant evidence commences. Before the defendant. So filing of a memo before the defendant commences evidence, reserving the right to lead evidence after knowing the evidence of the defendant would serve the purpose, and that is satisfy the requirement of law. Now earlier, before 76, the plaintiff and defendant, parties to the proceedings, are the last person to be examined. Many times this was abused. Therefore, the 76th Amendment, to see that there is a speedy disposal and there is no abuse of the provisions of the Civil Procedure Code, Order 18, Rule 3, capital A was introduced. By virtue of this provision, it was made mandatory or compulsory for the parties to enter the witness box first and then examine your witnesses. Of course, with an exception, in a given case, if there is some genuine difficulty, you can file an application and request the court to permit the party to be examined after the witnesses. Therefore, this Order 18, Rule 3, capital A, provided that where a party himself wishes to appear as a witness, he shall so appear before any other witness on his behalf has been examined. So he should be, PW1 should be the plaintiff, DW1 should be the defendant, unless the court, for reasons to be recorded, permits him to appear as his own witness at a later stage. So anyhow, this provision is now scrupulously followed in courts. It is the parties who enter the witness box first. Normally, PW1 is the plaintiff and DW1 is the defendant, and others are all witnesses. Because of this provision, the number of witnesses to be examined has considerably come down. A positive aspect, and this provision today, I can say with confidence, followed to the 99% in all courts. It is well taken. Now, this is what you are expected to do. Now the stage is set for examination of witnesses, hearing of the suit, and examination of witnesses. This word examination of witnesses, which is found in Article 18, you will also find in the Evidence Act in Chapter 10. Chapter 10 of the Evidence Act also deals with of the examination of witnesses. That is virtually, that's the substantive law. This is the procedural law. So what does Section 135 of the Evidence Act speaks about examination of witnesses? It speaks about order of production and examination of witnesses. The order in which the witnesses are produced and examined shall be regulated by the law and practice for the time being relating to civil and criminal procedure, respectively, and in the absence of any such law, by the discretion of the court. So, primarily, examination of witnesses, adducing evidence is a branch of Evidence Act. So, Section 135 says, that is regulated by the Civil Procedure Code. That is contained in Order 18. When they adduce evidence, when you examine witnesses, witnesses give evidence. What is the evidence they are going to give? Oral evidence and also documentary evidence. Now, insofar as this evidence is concerned, who should decide the admissibility? Is the plaintiff's lawyer, is the defendant lawyer, the parties, or the judge? Section 136 makes it very clear. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant. And the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. In other words, a judge has a role to play in the recording of evidence. He is not bound to simply, like a stenographer, go on recording what the witness says. Sometimes there will be a big galata in the court. You record. Why are you obstructing it? Have a right. What right you have? You have a right to leave relevant evidence. The judge has a right to control the leading of the evidence. If the judge asks you how it is relevant, the lawyer is duty bound to explain to the judge how that particular evidence is relevant. If the judge is not convinced, the law authorizes him to refuse to record evidence. This provision is provided to see that all irrelevant evidence is not entertained by the court, and thus the fair trial is going to be hampered because of that evidence. So therefore, it's time that stop quarreling with the judges. Of course, sometimes the judges are also interfering too much in the record of evidence by exercising their power. We have two extremes. That is the reason why I said the atmosphere of the court should be very cordial. It should be friendly. No one has a personal interest. Everybody is interested in administrative justice, and it should be regulated by law, and it should be conducted in a peaceful manner. There should not be, any ego clashes. Anyhow, that's the law of evidence which expressly provides for it. Now, having said this, Order 18 provides for recording of evidence. Now we have reached the stage of actual recording of evidence. Who has to begin? Who is to be examined? What is the power of the judge? Whether documents have come, witnesses is ready. We have seen all that. Now everything is in order. Now you have to record the evidence. In the recent amendment in 1999-22, a substantial amendment has been made in this particular field. Probably all these youngsters, lawyers, who are not put in 10 years, they have no idea. And the students who will become judges also have no, lawyers also have no idea. Prior to this amendment, when we are talking about recording of evidence, the plaintiff was put into witness box. And first, his evidence in chief was to be taken. After his exam in chief is taken, he would be cross-examined. And thereafter, there's an ambiguity to clarify that re-examination was permitted. Now, by the amendment, this examination chief of the plaintiff or defendant has to be by way of an affidavit. Therefore, the duty of examination in chief is washed out today. Conducting an examination in chief was more difficult than a cross-examination. Whenever we conducted examination, one hand was on the table. If the witness stupidly says something in exam in chief, his case is gone. Let him say anything in cross-examination, we can explain. But in the exam in chief itself, he says some damaging statement. The argument was, in exam in chief, we have said so, what more do you require? But anyhow, today, that botheration is not there. It is by way of a affidavit. I will come to that a little later. Now, what Order 18 Rule 4 says is, in every case, mark this word. There is a lot of confusion And there is a lot of fight also on this. In every case. What do you mean by every case? Every case means not 4,000 cases which are in that court. Broadly, in civil procedure code and in civil law, we have what is called as long cause. In Maharashtra, they call it as long cause. Here we don't call it. We say original suit is a long cause suit. A summary, small cause court is a small cause court, is a summary procedure. So in every case means whether it is a long cause or a small cause, we also call it appealable cases and not appealable cases. The examination in chief of a witness shall be on affidavit, and copies thereof shall be supplied to the opposite party by the party who calls him for evidence. So I told you, no evidence, more recorded. You put it in the form of affidavit, give it to the court, and give a copy to the other side. And then, where documents are filed, and the parties rely upon documents, the proof and admissibility of such documents, which are filed along with the affidavit, shall be subject to the orders of the court. So it provides examiner in chief by way of an affidavit. And if you are filing an affidavit along with the affidavit, filing documents along with the affidavit, that will be received by the court subject to the orders. I will elaborate it a little more afterwards. So therefore, law provides for filing of an affidavit by way of examiner in chief, and it also provides for producing documents along with the affidavit. If you go to Order 7, Rule 14, Order 8, Rule 1, capital A, it says all documents should be produced along with the pleadings, and you will not be allowed to produce any other documents except with the leave of the court. But here is a provision which says, at the time of filing the affidavit in exam in chief, if you want to produce some documents, you can do so, of course, subject to the orders of the court. So this is another stage where you can produce the documents. Now, what is important is Rule 2, the evidence, cross-examination and re-examination of the witnesses in attendance, whose evidence, that is exam in chief, by affidavit has been furnished to the court, shall be taken either by the court or by the commissioner appointed by it. For our purpose, let us forget about commissioner recording of evidence. We talk about recording of evidence by the court. So it speaks about exam in chief, cross-examination, re-examination. Now we have seen in civil courts, when trial goes on, I don't think any lawyer will allow the evidence to be recorded peacefully. There will be objections, heated exchanges. Sometimes witnesses are made alert. Sometimes witnesses are afraid in this galata, they do some blunders. So what is this law dealing with this exam in chief, cross-examination, re-examination? A lawyer should have a sound knowledge about this. That is not found in civil procedure code. Civil procedure code is the procedure law. The adjective law, Evidence Act, contains in detail provisions for this. So when you say I am conducting a case, unless you know the meaning of these words, the scope of these things, how will you conduct evidence? That is the reason why many times unnecessary heat is exchanged in an open court. So let us see what examination in chief, cross-examination, re-examination as defined under the Evidence Act. Evidence Act defines all these things. Section 137 of the Evidence Act speaks about examination in chief. The word exam in chief you found in Order 18, Rule 4. The examination of a witness by the party who calls him shall be called as the examination in chief. I am examining a witness. When I examine him in support of my case, that is examination in chief. After the examination in chief is over, examination in chief by itself is not evidence. It becomes evidence only when that witness is offered for cross-examination and is cross-examined. If you don't offer him for cross-examination, that evidence in exam chief of no use, it will be erased. So evidence properly understood means examination in chief and cross-examination. That is, what the witness said is tested in cross-examination. What is the object of cross-examination? If anybody is uttering a falsehood on board, cross-examination is the engine by which you try to expose it and get at the truth. So therefore, when you say evidence, and the court has to look into the evidence, it is the evidence which is tested in cross-examination. So therefore, what is cross-examination? Cross-examination is defined as examination of a witness by the adverse party shall be called the cross-examination. I examine a witness, it is examined chief, opposite lawyer, opposite party questions him, that is cross-examination. In the process, there may be some confusion, ambiguity. How do you clarify it? Therefore, the law provides for re-examination. What is re-examination? The examination of a witness subsequent to the cross-examination by the party who called him shall be called as re-examination. It is in this lot of heat is generated in court. When an attempt is made to put a question in re-examination, the opposite party will say, I have got a very good admission. There is no ambiguity. To get over that, he is putting this question. And the judge has to decide whether the question is a re-examination or a fresh examination. If it is only clarifying some doubt, ambiguity, it is re-examination. If the party wants to adduce fresh evidence, it is not in the statute. With the leave of the court, the plaintiff could request the court to permit it to put few questions in examination in chief. Once he is permitted to, normally permission is granted. Take it from me, 99% permission is granted. Once the permission is granted to do examination in chief, the other party has automatically a right to cross-examine. After a cross-examination, again you have a right to re-examination. This is where a lot of trouble in the courts. So once you know it, the object of this is to get at the truth. Let the witness say whatever he wants. In the end of the day, you can argue, the judge will have the material. Why not one sentence case is not going to be here. When the judge looks into the evidence, he looks into the entire evidence. And he has also seen the witnesses. He will observe the demeanor. And then he will decide the case. One should not be afraid. By one answer this way or that way, the fate of the case is not decided. So therefore, you must know what is exam chief, what is cross-examination, what is re-examination. Though law doesn't provide it with the permission of the court, you can put few more questions in exam chief. Then the other side will have a right to cross-examine. Then again, there's a right to re-examination. Now, when we talk about examination, cross-examination, re-examination, what is the order in which it is to be done? The law has not left it to the discretion of anybody. It has specifically said how it has to be. Section 138 of the Evidence Act speaks about order of examination. Witness shall first be examined in chief. Then, if the adverse party so desires, cross-examine. And then, if the party calling him so desires, be examined. So how beautifully it is. There is no ambiguity, no confusion to anybody. Examination in chief in the order first. There is no compulsion for the opposite party to cross-examine him. Assuming he has said something which is true, which is beneficial to him, why will he cross-examine? The whole object of cross-examination is to get at the untruth, to demonstrate the court this witness is not speaking the truth, and to get the truth from him. Assuming he has spoken the truth and it is helpful, there is no necessity to cross-examine. Similarly, after cross-examination, it is not necessary to re-examine unless there is an ambiguity. These are all options given to the party. Option may be exercised, it may not be exercised. It is not necessary. Merely because the option is not exercised, no adverse inference can be drawn against any person. And another important factor which the lawyers should bear in mind is the examination and cross-examination must relate to relevant facts. But the cross-examination need not be confined to the facts to which the witness testified on his examination in chief. Normally, there will be a big galata in the court. He is putting some question which is relevant. In examination in chief, you cannot put irrelevant questions. In cross-examination, your cross-examination need not be confined to only the questions put in examination. Is that not a correct understanding? I have said this in exam in chief. You confine your cross-examination only to this. No. In cross-examination, the lawyer has little more latitude. He may put questions to find out his veracity, his character, his background, to demonstrate to the court that he cannot be believed. All these questions is in no way connected with what he has said in exam in chief. The law specifically says cross-examination need not be confined to the facts to which the witness testified on his examination in chief. If you know this, there won't be any. Of course, if the cross-examination becomes scandalous and you want to harassing the witness, then you may raise a voice. But introductory few questions. Then who is your father? Who is your grandfather? Where you study? Are you married? You know that person? You know this person? It has nothing to do with the exam in chief. But the lawyer is trying to find out what the personality of the witness is. Whether even in these matters, which is not concerned with him, is the truth or false. So veracity of a witness is of utmost importance, and the attempt on the part of a lawyer in cross-examination to destroy his veracity and tell the court that his witness cannot be believed. So therefore, exam in chief should be relevant, and re-examination need not be confined to what has been said in exam in chief. It can go a little beyond here and there. Insofar as re-examination is concerned, again the law is very clear. The re-examination shall be directed to the explanation of matters referred to in the cross-examination. Something is said in exam in chief, he has been cross-examined. In the cross-examination, he has given some answer, probably contrary to what he has said in the exam in chief. And therefore, in re-examination, you cannot go on asking anything you want. But if a new matter is, by permission of the court, introduced in re-examination, the adverse party may further cross-examine upon that matter. These are all the rules which a trial lawyer should master. And when a right is given to a lawyer, you should respect it. Examine in chief, cross-examination, re-examination. Law says what questions could be put in exam in chief and what should not be put. In cross-examination, what you can ask, what you should not ask. And also it says what you can do it in re-examination. When you want to put something which does not fall within re-examination, take the point of the court and do it. Other side will have an option to cross-examine and then re-examination. And then everybody has the satisfaction that had a fair opportunity, fair hearing, where I have put before the court the best evidence which was in my possession. That's all the lawyer can do. So there should not be an attempt to block the evidence. The whole object of the entire inquiry trial is to get at the truth. And therefore, it is of utmost importance. Both the Evidence Act and the Civil Procedure Code sets out a procedure, a fair procedure, fair play. And the lawyer, the judge, the party, everybody should try to be within the four corners and do their best. Now, section 139 speaks about a person summoned to produce a document does not become a witness by the mere fact that he produces it and cannot be cross-examined unless and until he is called as a witness. Already I told you, you have a choice. You can summon a witness to come and give evidence. You can summon a witness to produce the document. You can also summon a witness to produce document and to give evidence. If you have not asked the person to to produce document and to give evidence, you have no right to cross-examine, or you have no right to cross-examine that witness or even examine the witness, because his job will be over the moment he produces the document. Section 140 of the Evidence Act talks about witnesses to character may be cross-examined and re-examined. That's where some latitude is given to the lawyers. And then, of course, this provision has probably become very redundant. That is, leading questions. Section 141 speaks about leading questions. Any question suggesting the answer with the person putting it wishes or expects to receive is called a leading question. As a rule, no leading questions can be put in the exam in chief. There are exceptions. But you can put a leading question in the cross-examination. You have seen in the cross-examination, I suggest to you this. You will say no. It is false to suggest. Answer is that. So you can make any suggestion in cross-examination. Then it becomes your case. At the same time, in examination chief, you cannot put any suggestion. It should be in the form of a question and he should answer. You cannot suggest to him the answer. That means you are putting a leading question, which is prohibited. So section 42 says, when leading questions can be asked, when it cannot be asked. When leading questions must not, if objected to by the adverse party, be asked in an examination in chief or in a re-examination, except with the permission of the court. The court shall permit leading questions as to matters which are introductory or undisputed, or which have, in its opinion, been already sufficiently proved. So therefore, that is a limitation imposed on leading questions. Today, though the examining chief is by way of affidavit, these provisions were subject to attack in the apex court, not once, twice. Please go through those judgments in the Salem Advocate Association case. Some of these provisions have been diluted to the Supreme Court to see that it is not void. One such interpretation placed by the Supreme Court is, you are a party, you have to give evidence. Your evidence can be by way of an affidavit. Suppose you want to examine a witness, say official witness. You take out summons, he comes. How can anybody compel him to file an affidavit? Who is going to draft an affidavit for him? He is not well versed. Again, if you are advocate to do it, we do not know what happens. Therefore, the Supreme Court said, as far as the parties are concerned, they have to file an affidavit. As far as the witnesses are concerned, they are given the option. If affidavit is prepared and is willing to say, this is my affidavit, the contents are true, take it. If he says, no, I will give evidence, I will enter the witness box. You ask me what you want. Then you have to examine him in chief. Then you cannot put leading questions. And if you put a leading question, the other side will object. Though leading questions can be asked in cross-examination, leading questions as a rule is prohibited unless there are admitted facts in this case. Your father's name is so-and-so, that is not in dispute. You are coming from this place, not in dispute. To cut short the time in recording evidence, you can put few leading questions and take the answer. Otherwise, no. So, the case is set down for evidence. The witness is in the box. He has to be examined in chief. So, you must have broadly this knowledge of Evidence Act vis-a-vis the Civil Procedure Code. Only when you know what is examined in chief, what is cross-examination, what is re-examination, what is the leading question, what questions to be put, what questions should not be put, what is the power of the court to permit you to put questions, what is the power of the court to refuse to record evidence. Probably the case which you are conducting would be in a proper course, in accordance with law, and probably justice could be ensured by following such a procedure. Now all that is said, witness is in the box. Now he is going to depose. Now the question is, as I said earlier, you have put a pleading. It contains material facts. A written statement is fine. Many of the material facts he might have admitted. if he has admitted a material fact, then there is no issue. Only when a material fact is alleged and the defendant denies it, an issue arises. And therefore, in every case, in the written statement, even though in the first part of the written statement, which is the specialization today, you deny all the 40 paragraphs in the plain, afterwards, when you set out your case, you admit many of the facts. So the question is, when he has admitted those facts in the written statement, and there is no issue framed in respect to that, when you are called upon to adduce evidence by way of examination, is it necessary for you to lead evidence to prove those material facts which are not in dispute, which are admitted? Section 58 of the Evidence Act deals with this. It says, facts admitted need not be proved. Facts admitted need not be proved. See, when we talk about court, when we talk about trial, when we talk about evidence, we are talking about proof. What is admitted need not be proved is the law. So section 48 categorically declares no fact need to be proved in any proceeding with the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by the pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admissions. So generally, admitted facts need not be proved. Sometimes this provision is abused. If a plaintiff files a suit, I'm giving an extreme, saying, I am the absolute owner of Vidhan Sauda. Defendant admits. Now the court has to grant a decree. I have seen some lawyers saying, you have no discretion. Once it is admitted in the written statement, court is bound to grant a decree. That is not the law. Even if the defendant admits the allegations in the plain, the court has the discretion and require the plaintiff to prove the so-called admissions by producing acceptable evidence. If he fails to produce acceptable evidence, notwithstanding the admission in the written statement by the defendant, the court may hold that the plaintiff's case is not proved and dismiss the suit. For generally, facts admitted need not be proved. Court will act on admissions and pass a decree. But if the court somehow feels something fishy, which is very prevalent today, collusive decrees. A forest land, a person claims a title, somebody says I have no objection, and the court grants a decree of title in respect of a forest land, and whole judicial process people look down at the judicial process. Did the judge have a brains or not? Merely because they collude. Because you see in most of the cases in Lok Adalat, first party files a caveat saying he is going to get an interim order. Then a plaint is filed. Then he enters appearance. Then he says, refer the matter to Lok Adalat. Next day it is referred. Then they file a compromise petition, admitting the claim. And our judges blindly put their seal. The fraud. Law does not provide for it. Evidence Act specifically says even if the defendant admits, the court has the discretion to say, come on, you prove it if you want a decree from me. If you don't prove it, I will throw it out. So therefore, this aspect, you should not quarrel with the judge. If you just say, come on, evidence, he said, no, who are you? You don't know the law. He has admitted it, pass a decree. You can't dictate terms to the court like that. Court has to be active, it has to be alive, it should be proactive, it should see what's happening in the court. And the court is not happy with the admission. If the court says, prove your case, the plaintiff cannot say, I will not produce, but accept the admissions. So this is the legal position that is well established, not today or centuries. And let there not be any unnecessary quarrel in courts on these aspects. Now, witness is in the box. Admitted facts need not be proved. Therefore, he has to adduce evidence in respect of disputed facts. He has to adduce evidence to discharge the burden of proving a particular fact which is on him by the way in which the issue is framed. Now, when he is expected to adduce evidence, evidence is of two types: oral evidence and documentary evidence. Again, the Civil Procedure Code, which speaks about examination of witness, production of oral evidence, production of documentary evidence, is silent about what is the nature of the evidence. To understand the nature of the evidence, again, you have to fall back upon Evidence Act. Therefore, knowledge of Evidence Act is a must before you put questions to your witness in the witness box, or even before you put the witness in the box, because you should know what you have to prove, what you are going to prove by documentary evidence, what you are going to prove by oral evidence, and what is the difference between oral evidence and documentary evidence. Now, what is to be proved by oral evidence is also explicitly stated in the Evidence Act. Section 59 of the Evidence Act speaks about proof of facts by oral evidence. So, with what oral evidence prove what fact? All facts except the contents of documents or electronic records may be proved by oral evidence. All facts may be proved by oral evidence except those exceptions. All facts except the contents of the documents and electronics may be proved by oral evidence. So therefore, in no way oral evidence is inferior. If there is no documentary evidence, if a fact is proved by oral evidence, the law provides for oral evidence. There is a contract. Law do not prescribe that contract should be in writing. If there is no such prescription, a contract could be oral, a contract could be in writing. Once a contract is in writing, it becomes documentary evidence. If the contract is not in writing, still that contract could be proved by oral evidence. And once that is in dispute, it is open to the party who has pleaded the contract to prove by oral evidence the existence of the contract. And if he is able to prove by satisfactory oral evidence the existence of the contract, and the court is satisfied, court can declare the existence of such contract. But when you are talking about oral evidence, there is a rider which is contained in section 60. If it is a case of oral evidence, it must be direct. It must be direct. What do you mean by direct? That is also exhaustively explained in that section. Oral evidence must, in all cases, whatever, without exception, be direct. That is to say, they are explaining what do you mean by direct. That is to say, if it refers to a fact which could be seen, if I have seen something with my eyes, which could be seen with the eyes of a person, it must be the evidence of the witness who says he saw it. If he has not seen it, and if he is giving evidence, it is no evidence, it is not admissible. If he has seen something with his eyes, and the person who has seen something with the eyes enters the witness box, takes oath, and says, this is what I saw with my eyes, that evidence is oral evidence, and that evidence has weight, and the court could act on that evidence. Mostly in these criminal cases, they call him as an eyewitness. That is, a person who has seen with the eyes the commission of an offense. In civil law, if he is giving an evidence, if he has seen with his eyes a particular act, a particular fact, and if he enters the witness box and both he says, I saw it, then it is an admissible, relevant evidence, oral evidence. The second type of evidence is, if it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. Only if you have heard it with your eyes and in the witness box you say, I heard it, then that evidence becomes oral evidence and direct evidence. If you have not heard it, and if you are saying something on the basis of somebody else, this is called as hearsay evidence. Hearsay evidence is not admissible. If you have heard it, by all means you say. If you say that man said he heard it, you should examine that person. You can't say what he said as heard it. That is called hearsay evidence. Hearsay evidence is inadmissible. If a judge is alert, he will not record hearsay evidence. If he is not alert, if he records evidence, he will not act on it. Hearsay evidence is not admissible. Court is justified in saying, I will not record it. Suppose the ingenuity of a lawyer or the judge is not alert and he does not know the consequences, he has recorded it. It could be pointed out in the argument. Look what he is saying. He did not something, he heard it. He says that man said something and that man is not examined. And this man can't say about what that man said to that man. And this is here as evidence and it is inadmissible. Then, if it refers to a fact which could be perceived, you must feel it by your hand, by your senses. ಮೂಗಿಗೆ ವಾಸನೆ ಆಗ್ಬೋದು, ನಾಲ್ಗೆದು ಆಗ್ಬೋದು, ಕೈ ಆಗ್ಬೋದು. By any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by the sense or in that manner. That is the evidence which a witness is expected to say in the witness box. Otherwise, it is inadmissible. The last one is if it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion in those grounds. If opinion evidence is adduced, it should be the evidence of that person who gave opinion. You cannot collect an opinion and produce it in court. It has no value. The other side accepts, fine. If it disputes it, you are producing the opinion of somebody else, or if you are saying that this is his opinion, it is inadmissible. If it is opinion evidence, it is the person who holds that opinion. He must examine. He should be subjected to cross-examination. Then it is for the court to accept or reject that evidence. So when we are talking about oral evidence, yes, oral evidence is admissible and oral evidence should be direct, and only if the oral evidence is direct, that is admissible and the court will look into it. So therefore, there is a misconception in law. Many lawyers, judges, what is the value to be attached to the oral evidence? In the absence of a documentary evidence, if a particular fact could be proved by oral evidence, and the person who has been examined has been truthful, he has deposed about what he saw, he deposed about what he heard, he deposed about what he perceived, and his evidence is withstood the test of cross-examination. And the judge has observed the demeanor of the witness, and the judge is satisfied that this witness is speaking the truth, he can act on that evidence and hold that particular fact is proved. Ultimately, it is the satisfaction of the court. It is the satisfaction of the court. Nobody can substitute his conclusion or opinion as far as the nature of evidence. So in no way oral evidence is inferior to that of documentary evidence. But if there is a oral evidence and documentary evidence on a particular fact, maybe the oral evidence gets precedence. In the absence of a documentary evidence, if a case has to be decided purely on oral evidence, and that oral evidence is given by a person who has seen it, who has heard it, who has perceived it, and he has withstood the test of cross-examination, that evidence is admissible and court would be justified in acting on that evidence and holding that particular evidence is true. In fact, there is another judgment law. When a trial court records a finding purely on the basis of oral evidence, after observing the demeanor of the witness, in appeal, even if the appellate court comes to another conclusion, and if two views are possible, the settled legal position is the appellate court should not interfere with that finding of fact based on oral evidence, because if two opinions are possible, he has one opinion, and that opinion is found after observing the demeanor of the witness, which opportunity was not given to the first appellate court. So therefore, the first appellate court, by merely looking into the words, has to record a finding. And the trial court not only has looked into the words, he has recorded the evidence, he has observed the demeanor of the witness, and then he is satisfied that what he is speaking is the truth, and he has recorded a finding. They say that finding, recorded with the trial court, should not be disturbed by the first appellate court, merely on the ground there is another view possible on the same set of evidence. So that's the importance. Therefore, when you are reading oral evidence in a trial, the lawyer must have all this in mind, and keeping that in mind, your examining chief should be there. Today, what is the examining chief? Plaint is converted into an appeal. What is the plaint? It contains pleas, it contains evidence, it contains argument, it contains judgment, it contains case law, statutory provisions. Is it in conformity with the law? Okay, we'll continue tomorrow.
Thank you, sir, for enlightening us and for your significant contribution. Progressing towards the question and answer session. So, the first question is, if some of the documents are not filed along with the plaint, can plaintiff file those documents subsequently before the commencement of the trial?
The law is now very clear. Earlier, there was a provision, Order 13, Rule 2, which gave an opportunity to the parties to produce the documents and initiate the proceedings by showing good cause for not producing at the stage when the document should have been produced. That was the most abused provision. Therefore, the parliament has deleted that provision from the Civil Procedure Code. Now, as the law stands today, the plaintiff and defendant has to produce all the documents on which they rely on along with the pleadings. Now, I showed you Order 18, Rule 4. When you file an affidavit by way of examining chief, and if you are producing some documents, yes, it could be produced with the leave of the court. The same provision says, though no document can be produced, with the leave of the court, documents can be produced. Now, not allowing the documents at a subsequent stage is the rule. In exceptional cases, courts have the power to grant leave to the parties to produce documents which they have not produced, either along with the pleadings or either along with the affidavit. The court has the power. You have to make out a case. If the court is satisfied, yes, it will be produced.
Thank you, sir. So the next question is, what is the scope of re-examination in the absence of examination in chief merely being through affidavit?
Though the examining chief is by way of an affidavit, what that affidavit contains? That affidavit contains the case of the plaintiff, the case which the witness wanted to say. If the witness had been examined in chief, judge would have recorded the evidence. Now, judge is not given the trouble. What he could have recorded is there in the affidavit. In the cross-examination, some answer is given, which may be contradictory to what is said in the examination, that is by way of an affidavit. Then an occasion arises to get a clarification. Therefore, perfectly a question could be put in re-examination to get over that ambiguity. So merely because examiner-in-chief is not done, it is by way of an affidavit. This provision for re-examination has not become redundant. Still, it has a purpose to serve.
Thank you, sir. So the next question is, what is the effect of the evidence of a witness who is partly cross-examined and dies before his cross-examination is fully completed?
A witness is examined in chief. He is offered for cross-examination. Once he is offered for cross-examination, a duty is cast on the defendant to cross-examine at length. If he had cross-examined at length and completed the cross-examination, if subsequently he died, it would not have mattered. You did not cross-examine them. Or probably witness was on that day was unable to withstand the day he himself sought, and it is adjourned, and subsequently he died. So at any rate, the plaintiff or the person who examined him cannot be found faulty, saying that he did not offer him for cross-examination. Similarly, you can't blame the witness did not step into the witness box for cross-examination. So in such circumstances, look at the cross-examination portion. That cross-examination is directed to some portion of the examination in chief. So to the extent questions are put to the answers given in exam in chief, that is admissible. If some area is not covered, that examination in chief has to be ignored. It is not a case where you cannot wipe out the entire evidence. If the witness is dead, if he has given answers in cross-examination, that area of exam in chief where cross-examination has been substantially done, certainly is evidence which the court can take note of. To the extent he has not been cross-examined, that evidence has to be ignored. It is not a case of complete erosion of his evidence.
Thank you, sir. So the next question is, after examination of plaintiff, and if there is no cross-examination of plaintiff, whether the plaintiff can be recalled at the stage of argument?
That's what I said. We have stages. Plaintiff was examined in chief. An opportunity was given to the defendant to cross-examine. If he commits a default in cross-examination, yes, evidence is, cross-examination is taken as nil, and that evidence is admissible in evidence, though it is not cross-examined. But if the defendant is able to make out sufficient cause for not cross-examining that witness on the day the case was posted for it, if the court is satisfied, court has the power to recall the witness, and that power could be exercised before the judgment is passed. Before the judgment is passed. At the stage of argument, even in cases where argument is over, case is posted judgment, if the court wants to recall it, it has the power.
Thank you, sir. Can the affidavit be amended? Is it permitted?
Affidavit?
Can be amended. Affidavit can be amended, or is it permitted, sir?
Yes, why not? Affidavit could be amended, additional affidavit could be filed, left to the party. If a mistake has crept into the affidavit, always you can make corrections. If some additional factors to be said, it is not by way of affidavit, you can file an additional affidavit.
Yes, sir. So the next question is, if the defendant failed to do cross-examination of PW1 and failed to do his evidence and matter is posted for main arguments, whether the defendant should file separate applications for reopening or recalling each stage, or if the cross-examination is reopened, automatically stage continues?
When the case is posted for arguments, if you want the evidence of a witness to be, he should be recalled for cross-examination, there is nothing like a reopening of a case. Case is still alive. Case is not posted for arguments. You can file an application for, that is, if the plaintiff side is closed, and then the case is posted for arguments, or defendant side is closed, then the case is posted for arguments. Then probably an application is required for reopening the case, then an application for recall. These are all procedural matters. Procedure is handmaid of justice, and we are wasting time on these things. The whole object is give an opportunity to cross-examine. In either way, if the judge insists on this, you can't find fault with him. If the judge is little liberal and say, come on, enter the witness box, and you have an opportunity, it is also perfectly all right. Procedure is handmade of justice.
Thank you, sir. So the next question is, if the defendant fails to file the written statement within time and the same is taken as nil, will the defendant have the right to cross-examine the plaintiff and further adduce defendant evidence?
Yes. When the defendant fails to file the written statement, all that happens is his defense is not there. But as long as he is on record, when the plaintiff gives evidence, he has a right to cross-examine the plaintiff's witnesses. And many cases, if the entire burden of proving the case is on the plaintiff, and by cross-examining the plaintiff, if the defendant is able to destroy his case, non-filing of the written statement is of no consequence. Plaintiff will be unsuited. He has a right to cross-examine even without filing the written statement. The defect is, if he does not file a written statement, he cannot say, this is my case. Your case you have not put forth. You cannot put a suggestion. You have to only cross-examine the plaintiff on what he has said and demonstrate that his case is not proved. You will succeed.
Thank you, sir. So the next question is, does the defendant reserve a right to cross-examine the witnesses even in the absence of a written statement?
There is no necessary question of reserving right will not arise. Reserving what are you doing? You are not filed the written statement. Plaintiff has entered the witness box. You are very much in the court. Cross-examine. You have a right. There is no question of reserving a right. Reserving a right, you must have done something. You have done nothing. Your right to cross-examine arises only after the pleadings are completed. So you have not filed a written statement. Question of reserving the right will not arise. Because you did not file the written statement, no issues are framed. Court has called upon the plaintiff to prove his case. Then he can stand up and say, I want to cross-examine. Fine. Nobody can compel a witness to file a written statement. It's an option given to you. He may say, I have no written statement. I will demonstrate to the court that the plaintiff's case cannot be believed. I will demonstrate to the court that the suit is not maintainable. I will demonstrate to the court that the plaintiff does not disclose cause of action. I will find out to the court that the suit is barred by any other law. The filing of a written statement is not a condition precedent for defendant to cross-examine the plaintiff. Without written statement, he can cross-examine.
Thank you, sir. So with your permission, can we take few more questions?
Yeah, sure.
So the next question is, should the defendant file an application under Order 8, Rule 8, when the plaintiff admits some documents shown by the defendant during the plaintiff's cross-examination in case the documents are not produced by the defendant along with the written statement?
That's what I said. You can always produce documents with the permission of the court. You have not produced the documents along with the written statement. If you want to rely on the document, you have a right to produce the documents along with the affidavit, evidence. Assuming the document is of very importance, you can always seek the leave of the court and produce the document.
Thank you, sir. Next question is, during a trial, how appropriate is it to use digital evidence, like showing a video proof on a mobile or a tablet, directly to the presiding officer in the open court? Because when a CD is marked as an evidence, it's not possible for the advocate to be present next to the judge to make his point while he watches it in his office.
They are all problems of virtual hearing. So we have to sort it out in days to come. In days to come. It's left to the judge, it's left to the lawyer, the opponent. It should be done by agreement.
Thank you, sir. So the next question is, what is the difference between onus of proof and burden of proof?
The burden of proof will never shift. A plaintiff has come to the court, defendant has denied his case, and therefore the burden of proving his case always is in the plaintiff. Once the plaintiff adduces evidence, he has discharged the onus and the onus shifts to the other side. So defendant leaves evidence. He discharges his burden and again the onus shifts on the plaintiff's side. Again plaintiff can leave some evidence. And at the end of the day, after the entire evidence is over, this burden of proof, onus of proof, all goes to the background. What the court has to do is look at the evidence and find out whether a particular fact is proved or not.
Thank you, sir. Sir, if by inadvertence, the procedure stipulated under Order 12 and 13 is not applied by the previous counsel for plaintiffs, Can the counsel on record at present get it implemented when the stage is set for cross-examination of defendants?
Stage is over. Stage is over. The whole object of those provision is to restrict the scope of trial. Once the trial has commenced, everything is wide open. There is no question of you are asking for interrogatory, all those things. The stage is over.
Thank you, sir. So the next question is, can the memo be filed by the counsel for plaintiff when the stage is set for cross-examination of defendant? Only affidavit evidence of defendant is completed.
What memo? What is the memo?
He's just saying memo, sir.
What is the memo? You must say memo should contain something.
I will clarify it, sir, and then we'll take the question.
Question is vague. You move on to next question.
Sir, should the re-examination be oral or in writing? And can the party intend to re-exam, seek time to re-exam on the next date?
Generally, time should not be granted for re-examination. Because when the case is urgent for re-examination, it's possible that he will be educated about what question we put, what answer is required. But sometimes, if the cross-examination has run for several days, several ambiguities are created, then certainly an opportunity is given by way of an adjournment, and on the adjourned date, re-examination is done. But generally, re-examination should be done then and there, and time should not be given for re-examination because chances are it will be misused.
Thank you, sir. And one last question for the day. When the defendants fail to file written statement, can the judgment be passed upon the application filed by the plaintiff under Order 7, Rule 10 of CPC? Even after the application is filed, can the court dismiss the application and permit the defendant proceed with the case?
Order 7, Rule 10 speaks about return of plaint. So where the question of you are filing Order 7, Rule 10 application because the defendant has not filed the statement. So Rule 10 speaks about Order 8, Rule 10 says when the defendant fails to produce the written statement. So what is the question?
When the defendants fail to file written statement, can the judgment be passed upon the application filed by the plaintiff under Order 8, Rule 10 of CPC? Even after the application is filed, can the court dismiss the application and permit the defendant to proceed with the case?
No, I am not able to understand. Order 8.
Question is also very vague.
Very hard. All right.
Very vague.
Please check up the question and put that question tomorrow.
Yes.
Order 8, Rule 10 speaks about passing an ex parte order.
Yes, sir.
It's not an application. Power of the court to pass an order where no written statement is filed. It only speaks about how that judgment should be.
Yes, sir.
Tomorrow ask him to put a question after having some clarity.
Yes, sir. Thank you, sir, for answering all the questions patiently. A British statesman, politician, military officer, and also who served as the Prime Minister of Great Britain, Winston Churchill, says that success is not final, failure is not fatal. It is the courage to continue that counts. With this note, I would like to extend my heartfelt gratitude to our renowned dignitary, Hon'ble Justice N.Kumar, and sir will be addressing on the same topic tomorrow. I would also like to thank Shri Anil Kumar JM, Chairman of Karnataka State Bar Council, Shri Gautam Chand SF, President of CPC Law Academy, all the members of Karnataka State Bar Council, trustees of CPC Law Academy, hosting committee members, guests, advocates, and all the participants for your prolonged and vigorous participation. Thank you all.